Mediation is a statutory provided tool by which parties that have reached a stalemate in negotiations can obtain the services of a state mediator. Mediation is a method of resolving disputes, a form of alternative dispute resolution, in labor negotiations by employing a neutral third party, in this case a mediator, to assist the parties in reaching an agreement by maintaining communication and encouraging them to move towards a common goal. The Bureau of Mediation Services describes mediation as meeting to help the parties find a basis for resolving the dispute on the terms acceptable to both parties. Mediation is a continuation of the negotiation process. It's not binding like arbitration. The mediator examines and analyzes positions and interests to ensure both parties have a clear understanding of the issues. The mediator will attempt to identify priorities and focus the parties' efforts on problems that must be solved for an agreement. The mediator works for the Bureau of Mediation Services. Employers and unions are statutorily required to participate when summoned to mediation by the Bureau of Mediation Services. The mediator works to foster an atmosphere conducive to idea sharing and problem solving. Ultimate decision-making in mediation is left to the parties. The mediator will not impose a settlement on the parties. Either the agency or the union can petition the BMS for mediation. The BMS also may mediate even if a petition has not been filed. The petition must be submitted to the Commissioner in writing, and the petition must state briefly the nature of the disagreements of the party. Upon receipt of petition for mediation, the BMS will assign a mediator to the case. Subject to availability, the parties may request a mediator they have worked with in the past. The mediator will generally contact the representatives listed on the petition and set up a date for mediation. This may occur in one, sometimes a long meeting, or over several short meetings, depending on how many issues there are to resolve and the complexity of those issues. The primary obligation of the agency is to come to mediation meetings with good faith intent to attempt to resolve issues. The parties are statutorily required to respond to the summons of the BMS Commissioner to attend mediation. The parties are also required to continue in conference until excused by the mediator. The parties must be represented by persons having the authority to negotiate in good faith and must be prepared to identify unresolved issues in their positions regarding such issues. However, there may be times when it's in the agency's best interests to hold firm on one or more positions for fiscal reasons or because the need to maintain a critical management right. Good faith intent does not mean the agency must agree with all or any of the mediator's proposals for settling the disputed issues. The mediator cannot substantively decide to resolve a dispute. The mediator's control is primarily related to process. The parties are not permitted to leave mediation unless excused by the mediator. It is often the case that mediation meetings will be held at the employer's facilities. Where the mediator determines there's a need to meet off-site to be more productive, such as to avoid outside distractions, mediation may also occur at the BMS offices in St. Paul or some other site. Accordingly, the employer should make arrangements for a meeting room large enough for both parties to meet in, along with a second room for one of the parties to use when the groups separate. The mediator supplied by the BMS should be considered the boss to some extent. The mediator will direct the way the meeting will be held, but is usually open to input from participants. The mediator's job is to try to find methods to settle the issues between the two parties. Each mediator has their own methods or preferred approach for accomplishing this. Regardless, the mediator is always neutral and will generally not take sides on an issue. A good mediator will try to persuade both sides to compromise or give in on an issue when appropriate. The mediator may disclose information about either party's chances of winning in arbitration for essential groups. The mediator's role is as a facilitator rather than a decision maker. The mediator's primary authority is that the parties must remain in the mediation session until excused by the mediator. One area where a mediator does wield considerable authority relates to declaring an impasse. Under labor law, an agency cannot unilaterally implement its final offer to a non-essential employee group until the parties have reached an impasse. Employees can strike without a mediator making a determination about an impasse, provided they meet preconditions such as participating in mediation for a certain period of time and providing the required notice for a strike. This means that an agency cannot simply implement a final or best offer in the event that employees go on strike. For essential employees, the mediator will have the authority to certify which issues may be submitted to interest arbitration. This will consist of those issues where the mediator has determined that both parties have made substantial, good faith bargaining efforts and an impasse has occurred. An agency or a union may not submit issues to interest arbitration unless they've been certified by the BMS through a mediator. The process of mediation may vary depending on the mediator. The general preference of most mediators is to separate the parties following an introductory portion of mediation into separate rooms. The mediator will typically start in the room with the party who filed for mediation. This is typically the union. The mediator will discuss open issues and explore areas of potential compromise or mutual interest. The mediator will then go to the other room where the other party is located and engage in the same type of discussion. This is often called shuttle diplomacy. This will allow the mediator to identify whether there are some areas where agreement may be reached, or at least where the dispute may be narrowed. Having these discussions occur in separate rooms can allow a more open and frank conversation without the need for positioning. After the initial discussion, any of the parties, including the mediator, can put forward proposals to settle the issues under discussion. Where the exchange of proposals is not productive or fruitful, the mediator may try alternative methods to identify potential areas of agreement. One method is to have the chief spokesperson for the agency and the chief spokesperson for the union meet together outside the rooms where the negotiating teams are present. Another method is for the mediator to listen to both sides as they exchange proposals and then put together what the mediator views as a potential resolution to the disputed items. This is commonly called a mediator's proposal. The advantage to such a proposal is that it allows a neutral person with access to both rooms to identify those areas of importance to both parties and attempt to fashion an acceptable resolution. The disadvantage is rejection of the mediator's proposal, limiting the ability of the mediator to use the same technique later in the process. A third method is for the mediator to present a what-if scenario. In this instance, the mediator will identify what a party would possibly be willing to accept as a compromise and, with that party's permission, verbally present that potential compromise to the other party to see if it's acceptable to the other party. Ultimately, through these various exchanges and discussions, the parties will either reach agreement or the mediator will agree the parties have reached an impasse. Generally, impasse is the point in time where the parties are unable to reach an agreement. It is a factual determination including consideration of whether the parties have negotiated in good faith, the length of time of negotiations have taken place, the history of negotiations, the nature and importance of the issues left in dispute, and the positions taken by the parties. If the parties reach impasse and the group is defined as non-essential, the employees may go on strike following the prerequisites of a strike. Conversely, the agency may implement its last best offer. A third option is for the parties to simply continue under the status quo but no longer meet. Unions may find themselves in this position if the membership does not accept results of negotiation yet does not authorize a strike. Continuing the status quo with an expired contract typically means simply continuing to operate under the terms and conditions of that contract. In contrast, essential employee groups may not go on strike. Rather, unresolved disputes following mediation will be referred to interest arbitration.